This courtroom moment is intense from start to finish. In this video, a self-proclaimed sovereign citizen tries to challenge the judge's authority, questioning the court's jurisdiction and the charges against him. He uses complicated legal terms, attempting to twist the law in his favor, but the judge quickly makes it clear that this is a real criminal case involving driving with a suspended license. As the hearing continues, the defendant refuses to back down, repeating the same arguments and interrupting the court. The judge patiently explains the situation multiple times, warning that the charges could lead to serious consequences, including jail time. When it becomes clear that the defendant won't cooperate, the judge takes control of the courtroom and shuts down the exchange. The tension rises even more when the judge warns that if a $1,000 bond isn't paid within 48 hours, a warrant will be issued. This dramatic showdown shows exactly what happens when internet legal theories collide with real-world justice.
00183, People of the City of Berkeley versus Kamash Baku Myrick.
Magistrate, I'm just going to acknowledge my presence for the record. Patrick Agnick. I'm here as appointed counsel on behalf of the arraignment docket this morning. I did speak to Mr. Myrick in private. I did explain to him he does have the right to counsel. I explained to him, obviously, that right. He's indicated to me unequivocally that he does not want counsel. Mr. Myrick, is that a fair statement?
That is a fair statement.
So with that said, I'm here and present, but with that, I believe Mr. Myrick will address the court on his own behalf.
Mr. Myrick, you have the right to decline counsel. You also have the right to change your mind. If you do, just notify the court.
Yes, sir.
You've been charged in this citation that was issued on the 22nd day of January at about 5:58 in the morning with driving in the city of Berkeley on Henley near Franklin Street while your license to do so was suspended. Driving on a suspended license is a crime for which you could be incarcerated up to 93 days and or fined $500. You have a right to a trial. Trial can be before a judge or a jury. You can act as your own attorney or you can be represented by counsel. If you cannot afford to retain your own attorney, an attorney can be appointed for you. You'd have the right to confront and cross-examine the witnesses against you. You'd have the right to testify yourself or not to testify. In the event that you choose not to testify, your silence cannot be used against you. You have the right to be presumed innocent until you're proven guilty beyond a reasonable doubt. The court's going to enter a plea of not guilty on your behalf.
No, sir. I don't even understand the charges here.
The charge is driving a car on the streets of the city of Berkeley while you're not licensed. You're suspended. That's the allegation.
Well, I totally understand, and I would love to plead, Your Honor. But before I have some questions on the record before moving forward and concerning the subject matter of the jurisdiction and the nature and cause of the action that's brought against you.
The cause brought against you is a criminal charge.
Okay.
Alleging that you were operating a motor vehicle on the streets of the city of Berkeley while your driver's license was suspended by the Michigan Secretary of State. That is the nature of the charges brought against you.
Thank you, Your Honor. For the record, are you saying that these are criminal charges?
Yeah.
Okay, Your Honor. Further, that brings a little bit more confusion for me because under the Constitution, there are two criminal jurisdictions. One is under the common law, and the other one is under admiralty, and that's a military tribunal venue. And under Article 1, Section 8, Clause 17. Which one of these criminal jurisdictions am I being brought on charges under?
Mr. Myrick, your perception as to the nature of the Constitution and its implications is grossly distorted. You're not dealing with reality.
Objection, Your Honor.
You can object all day long, but the bottom line is that what you are alleged with doing is a crime, and you can face you are facing criminal prosecution here with a potential jail sentence of 93 days. Now, this isn't complicated. If you want to come up with words that don't make sense, keep talking. But the bottom line is that there's no correlation with what's going on here and admiralty law whatsoever. And the common law is a civil concept. We have statutes in the state of Michigan, as do all 50 of the states. The federal courts have statutes, and common law is a civil thing. There's no common law crimes.
Exactly. So you ruled out the common law, Your Honor. So the other criminal jurisdiction that I can be brought in charges under is under admiralty, and that is a military tribunal.
There is no basis in law or fact for the conclusion that you stated, sir.
Your Honor, you
need a lawyer.
I'm under a criminal. This is a criminal charge, correct?
Yeah.
So which of the two criminal jurisdictions?
You haven't heard what I've said, sir. This is not a matter of having the two choices that you have spoken to.
Wow.
You are misreading the Constitution of the United States, the Constitution of the state of Michigan, and the statutes that are brought against you here. There's nothing to do with admiralty. You weren't in a boat.
Well, Your Honor, you two have a sworn oath of office.
I am sworn to uphold the Constitution of the United States, the Constitution of the state of Michigan, and the statutes related thereto. And that means that I'm not going to.
So you do have a Sixth Amendment obligation to inform me of what jurisdiction.
And I think I have done that. I have told you that the people of the city of Berkeley have brought charges against you.
Well, Your Honor, the people is not a person. If I'm being brought up under criminal charges, there needs to be a corpus delicti, which there isn't. So I'm asking you.
Do you know any other legal words? Why don't you just mix and match them here?
Well, this
maybe you could get a Department of Labor form and read a couple lines of that into this record too, or maybe you'd like to deal with the probate code. But the reality, sir, is that you've been charged with a city ordinance violation. It's clear what the ordinance says. It's clear what you've been charged with. You have a right to be presumed innocent, and you have a right to a trial. We're going to set this for pre-trial before the trial. You'll be notified by mail. Do you still live on Mendota?
I do, but I have
What
not.
Is your phone number?
I'm not issued a plea, Your Honor.
I have entered a plea of not guilty on your behalf.
I object.
What is your phone number?
You cannot
sir?
enter a plea. I do not. I have not entered a plea.
I just did.
Your Honor.
What is your phone number?
There is no plea that you can put enter in because I didn't voluntarily enter in the plea, Your Honor. I'm asking you, Your Honor.
You want me to enter a plea of guilty?
Under the two jurisdictions that
there's not two jurisdictions.
There's only two jurisdictions that I can be charged under the Constitution,
no, that's
Your Honor.
Mr. Myrick. That's what your conclusion that there's only two jurisdictions here is absolutely without merit.
Your Honor, you said that this is a criminal charge. I'm asking you, Your Honor.
I'm asking you what your phone number is. Let's get down to basics here. You're making this very hard on yourself.
Your Honor, I
What's
have
your
the
phone
right
number?
to assert my right, Your Honor. And
What is your phone number?
Your Honor.
What is your phone number?
My phone number, Your Honor, is...
Yes, I'd like to know it.
Your Honor, we haven't even established what jurisdiction we're in.
I have established that. I told you it's the people of the city of Berkeley that brought the charges against you.
Your Honor,
you said that three times now.
You stated on the record that these were criminal charges, Your Honor. I need to have an understanding. By the Constitution, Your Honor, there are only two criminal charges.
Where does the Constitution say you have to have an understanding?
Say again, Your Honor?
Where does the Constitution say you have to have an understanding?
By the Sixth Amendment, Your Honor. The
Sixth Amendment says you have to understand. The Sixth Amendment can't make you understand if you're being unreasonable.
But, Your Honor, I have the right to understand what jurisdiction I'm being brought under, and you have an obligation to inform me of that jurisdiction, Your Honor.
Which I have done about 17
by the
times.
Constitution under Article 1, Section 8, Clause 17, Your Honor.
Mr. Myrick, your bond is $1,000 cash or surety. It must be paid within 48 hours or there'll be a warrant issued for your arrest.
Your Honor.
That's done. We're through. Good luck.
Your Honor.
Get your own lawyer.
Your Honor, you have not given me a jurisdiction, Your Honor.
I've given you a jurisdiction 4 times. I'm not going to waste any more time.
This courtroom hearing starts off like many others, but within seconds it becomes clear that this is not going to be an ordinary proceeding. The judge calls the case, expecting a routine exchange about a criminal charge. Instead, the defendant immediately shifts the tone. Rather than confirming his identity or responding directly to the court, he begins questioning the court's authority. He asks about jurisdiction. He challenges the nature of the charges. He speaks in rehearsed legal phrases that sound carefully memorized but strangely disconnected from the reality of the situation. The judge listens at first. There's patience in the response. The court attempts to bring structure to the conversation, explaining that this is a criminal matter. The defendant is charged with driving with a suspended license. It's not theoretical. It's not philosophical. It's not a debate about the structure of government. It is a straightforward criminal allegation with potential penalties attached. But instead of addressing that charge, the defendant continues down a different path. He insists that he does not recognize the authority of the court. He demands proof of jurisdiction. He references constitutional ideas and vague legal doctrines, suggesting that the system itself is flawed and inapplicable to him. The language sounds formal, but it lacks substance. It's as if he believes that saying the right combination of words will somehow dismantle the case. The judge responds clearly and directly. The court explains that jurisdiction has already been established. The charges are valid under state law. The defendant's driver's license was suspended, and he is accused of operating a vehicle regardless of that suspension. The consequences are real. Fines are possible. Jail time is possible. A criminal record is possible. These are not imaginary outcomes. Still, the defendant refuses to engage with the substance of the case. He circles back to the same claims, asking whether this is common law, whether this is maritime law, whether the court is operating under some hidden authority. The judge attempts again to simplify the matter. This is a criminal courtroom. The charge is driving with a suspended license. The law applies equally to everyone in the jurisdiction. There is no secret loophole. There is no hidden technicality that removes responsibility. As the exchange continues, the tension builds. The defendant interrupts repeatedly. He avoids answering direct questions. Instead of entering a plea or discussing the facts, he returns to arguments about sovereignty and personal interpretation of the law. It becomes clear that he is not trying to resolve the case. He is trying to challenge the legitimacy of the entire process. The judge's tone begins to shift. The patience is still there, but it becomes firmer. The court explains that repeating the same arguments will not change the outcome. The defendant is warned that failure to cooperate can lead to additional consequences. The judge emphasizes that the court has explained jurisdiction multiple times already and will not continue debating it endlessly. At one point, the judge outlines the seriousness of the situation in unmistakable terms. This is not a game. Driving with a suspended license is a criminal offense. If convicted, the defendant could face jail time. The judge makes it clear that continuing to argue about abstract legal theories will not erase the charge. The law does not bend simply because someone claims independence from it. The defendant, however, appears unmoved. He insists that he is not subject to the court's authority. He attempts to control the dialogue by asking his own questions instead of responding to the court's. The dynamic becomes increasingly strained. The judge tries again to redirect the hearing toward practical matters, bond conditions, procedural steps, the timeline of the case. Eventually, the judge addresses the immediate issue of bond. The defendant is informed that he must post a $1,000 bond within 48 hours. The warning is direct. Failure to do so will result in a warrant being issued for his arrest. This is not framed as a threat but as a procedural reality. The court system operates according to established rules. Ignoring those rules carries consequences. Even at this stage, the defendant continues to resist. He attempts once more to challenge the foundation of the court's authority. The judge, now clearly finished with the circular debate, states that the matter has been explained repeatedly. There is nothing more to clarify. The court will not waste additional time on arguments that have no legal basis. The hearing reaches its breaking point. The judge asserts control decisively. The defendant is effectively shut down and disconnected from the virtual proceeding. The courtroom returns to order. The message is unmistakable. The judicial system will not entertain endless arguments rooted in internet conspiracy theories. What makes this exchange so compelling is not just the confrontation itself, but what it represents. It highlights a growing trend of individuals who rely on misinformation, believing that certain phrases or interpretations of the law can shield them from accountability. The courtroom becomes the collision point between those beliefs and the structured reality of the legal system. Throughout the hearing, the judge demonstrates a balance between patience and authority. There are multiple opportunities given for the defendant to engage properly. There are repeated explanations of jurisdiction. There are clear warnings about consequences. Only after those efforts fail does the judge take stronger action. The case itself is straightforward. A suspended license. An alleged violation. A criminal charge. Yet the simplicity of the charge contrasts sharply with the complexity of the defendant's arguments. Instead of focusing on defense strategies grounded in actual law, he chooses to dispute the system itself. As the hearing closes, one thing is clear. The court operates within established legal frameworks that do not disappear when challenged rhetorically. Words alone do not override statutes. Personal belief does not cancel criminal charges. And courtroom proceedings are not platforms for abstract political debate. This dramatic exchange serves as a powerful reminder of how the justice system responds when faced with defiance based on misinformation. It shows the limits of patience. It shows the importance of procedure. And ultimately, it shows that in a court of law, reality prevails over rhetoric.